I was sitting on my Snowmachine in the middle of my property, staring at a line of 6 tourists on rented snowmobiles following some guy in a bright orange vest who was giving them a tour of what he called Alaska's premier backcountry trails. And I realized that the HOA had finally gone too far. My name is Yates Kellerman, and I own 47 acres of pristine wilderness about 30 miles outside of Fairbanks, Alaska. I bought this land 5 years ago specifically because it was remote, beautiful, and most importantly, it had natural trails perfect for snow machining. I spent 3 winters clearing additional paths, marking routes, and creating what I considered to be my own private paradise. The trails wound through dense spruce forests, across frozen creeks, and up to a ridge that gave you a view of Denali on clear days. I had poured thousands of dollars and hundreds of hours into making these trails safe and enjoyable. The problem started when developers built a fancy subdivision called Northern Lights Estates, about 2 miles from my property line. They marketed it as a luxury community for people who wanted to experience authentic Alaska living, while still having heated driveways and wine bars. The HOA that came with it was run by a woman named Patricia Kendrick, and she was exactly the type of person you would expect to move to Alaska and immediately try to change everything about it to suit her vision of what Alaska should be. I had first met Patricia about 6 months after the subdivision opened. She showed up at my property with a clipboard and a smile that looked like it had been practiced in front of a mirror. She was in her late 40s, with blonde highlights that definitely came from a salon, and she wore one of those puffy designer jackets that cost more than my snow machine. "Hi there," she had said, extending a manicured hand. "I'm Patricia Kendrick, president of the Northern Lights Estates HOA. I wanted to introduce myself to all the neighbors." I shook her hand, noting that her grip was limp and her hand was cold. "Yates Kellerman, nice to meet you, but I should mention I'm not part of your HOA." Her smile had faltered slightly. "Oh, I know that. But we do believe in being good neighbors to everyone in the area. I actually wanted to talk to you about your beautiful trails. Some of our residents have mentioned seeing them, and we were wondering if you might consider allowing limited access for our community members. We would be happy to contribute to maintenance costs." I had been firm but polite. "I appreciate the offer, but these are private trails on private property. I built them for my own use and for my friends. I'm not comfortable with strangers using them." Patricia's smile had frozen in place. "I see. Well, if you change your mind, please let us know. We really do want to foster a spirit of community cooperation in this area." That had been 8 months ago, and I thought that was the end of it. I was wrong. The first time I noticed something was off was in early January. I was running my trails on a Saturday morning when I saw fresh snow machine tracks that I didn't recognize. Alaska has a pretty active snow machining community, and occasionally people would accidentally cross onto my property, but these tracks were numerous and clearly following my marked trail system. I figured it was just some folks who didn't realize they were on private land, so I put up a few more private property signs at key entry points. 2 weeks later, I found a dropped glove on one of my trails, and then an empty energy drink can. I was getting annoyed. I started checking my trails more frequently, and that's when I noticed the pattern. Every weekend, usually Saturday afternoons, there would be multiple sets of fresh tracks on my trails. Not just 1 or 2 machines, but 5 or 6 at a time, all following the same route. I decided to stake it out. On the next Saturday, I positioned myself on a ridge that overlooked the main entry point to my trail system. I didn't have to wait long. Around 1 in the afternoon, I saw them coming. 6 snowmobiles, all rentals based on their matching appearance, followed by a seventh machine driven by a guy in an orange safety vest. They turned onto my property without hesitation and started following my trails. I fired up my snow machine and intercepted them about a quarter mile in. I pulled across the trail and killed my engine. The tour guide stopped and the tourists bunched up behind him. I climbed off my machine and walked over. "Can I help you folks?" I asked, keeping my voice level. The tour guide pulled off his helmet. He was younger than I expected, maybe mid-20s, with a scraggly beard and a nervous smile. "Hey man, we're just running the trail here. Beautiful setup you've got." "It's my setup," I said. "This is private property. These are private trails. You're trespassing." His smile faltered. "Oh, I was told these trails were open for tours. I work for Northern Lights Adventure Company. We've been running this route for about a month now." "Who told you the trails were open?" I asked, though I was already pretty sure I knew the answer. "The HOA at Northern Lights Estates. They said these were community trails that we could use for our tour operations. They even gave us a map." I felt my jaw clench. "Let me see that map." He pulled out a laminated map from his jacket. Sure enough, it showed my entire trail system, marked as Northern Lights Trail Network with various points of interest labeled. At the bottom, in small print, it said courtesy of Northern Lights Estates HOA. "All right, listen," I said, handing the map back. "I don't know what the HOA told you, but they lied. These are my private trails on my private property. The HOA has no authority here whatsoever. I need you to turn around and leave, and I need you to not come back." The tour guide looked genuinely distressed. "Man, I'm really sorry. I had no idea. My boss is going to kill me. We've been advertising this tour. We've got bookings through March." "That's not my problem," I said. "You need to take it up with whoever told you that you could use my land." The tourists, who had been watching this exchange with growing concern, started asking questions. One older man asked if they were going to get a refund. A woman wanted to know if they could at least finish this one tour since they had already paid. I held firm. Everyone turned around and left. As soon as I got home, I called Patricia Kendrick. The number was on the HOA website for Northern Lights Estates. She answered on the third ring. "Patricia Kendrick speaking. This is Yates Kellerman. We need to talk about my trails." There was a pause. "Oh, hello, Yates. What about them?" "You've been telling a tour company that they can use my private property for commercial operations. That stops now." Her tone became defensive. "I don't know what you're talking about. We simply mentioned to a local business that there were some nice trails in the area. You gave them a map of my trail system and told them it was a community trail network. I just had to turn away a group of tourists who were on my land right now." "Well," Patricia said, her voice taking on that particular quality that I was learning to associate with her, a mix of condescension and fake sweetness. "If you had agreed to share the trails with the community in the first place, we wouldn't have this problem. Those trails connect to public land in several places. I think you'll find that the situation is more complicated than you think." "The trails are entirely on my property," I said. "I had the boundaries surveyed when I bought the land. There is nothing complicated about this. Tell your tour company to stay off my land, or I'll start filing trespassing complaints." "That seems a bit extreme, Yates. We're all neighbors here. Surely we can work something out." "We already worked something out," I said. "I told you no 8 months ago. That's still my answer. Stay off my trails." I hung up before she could respond. I was furious. I spent the rest of the day adding more signs to my property. I put up no trespassing signs, private property signs, and trail closed to public signs at every entry point I could find. I used bright orange signs that were impossible to miss. The next Saturday, I checked my trails again. Fresh tracks, multiple machines. They had completely ignored my signs. I called the Alaska State Troopers non-emergency line and explained the situation. The dispatcher was sympathetic, but explained that property disputes like this could be complicated, and unless I caught someone in the act and wanted to press charges, there wasn't much they could do. She suggested I might want to consider installing cameras or physically blocking the trails. I didn't want to block the trails. These were my trails and I used them constantly. I shouldn't have to destroy my own trails to keep trespassers out. Instead, I bought a trail camera and mounted it at the main entry point, hidden in the trees. The camera was motion activated and would send photos to my phone. The following Saturday, I got the photos. The same tour guide, the same rental snowmobiles, and this time I could clearly see the tourists' faces. I also got photos of them throughout the trail system from 2 other cameras I had placed. This was deliberate, repeated trespassing, and now I had proof. I called the tour company directly. Northern Lights Adventure Company had an office in Fairbanks, and I reached the owner, a guy named Dale Pritchard. "This is Yates Kellerman. Your company has been running tours on my private property without permission. I need it to stop immediately." Dale sounded confused at first, but as I explained the situation, his tone changed. "Mr. Kellerman, I am very sorry. I was absolutely told by the HOA that we had permission to use those trails. I have emails from Patricia Kendrick explicitly stating that the trails were available for commercial use and that the HOA had the authority to grant access." "The HOA has no authority over my property," I said. "Can you forward me those emails?" "I'm not sure I should share private business correspondence," Dale said hesitantly. "Your employees are trespassing on my property for profit. I have photographs, and I'm prepared to file criminal charges." "I think sharing those emails might help establish that you were acting on bad information, rather than knowingly trespassing." There was a long pause. "Let me call you back." 20 minutes later, my email dinged. Dale had sent me a chain of emails between himself and Patricia. The correspondence was damning. Patricia had clearly represented herself as having the authority to grant access to the Northern Lights Trail Network. She had sent the maps, discussed fees for trail maintenance, and even suggested the tour company might want to contribute to a trail improvement fund that the HOA was supposedly managing. There was no mention anywhere that the trails were actually privately owned by someone outside the HOA. I forwarded the emails to my own account and then started making phone calls. First, I called a lawyer in Fairbanks named Mitchell Hayes who specialized in property disputes. I explained the situation and emailed him the documentation. Mitchell read through everything while I waited on the phone. "This is pretty clear-cut," he said. "The HOA has no authority over your property, and they appear to be fraudulently representing themselves as having that authority for financial gain. That second part could actually be criminal. Have you lost any income from this?" "I haven't been charging anyone to use my trails," I said, "but I've had to spend time and money dealing with this, and the increased traffic is causing damage to the trails." "We can pursue this civilly for sure," Mitchell said. "We should send a cease and desist letter to the HOA immediately. We should also send one to the tour company, though it sounds like they were acting on bad information. As for criminal charges, you might want to file a report with the troopers about the fraud aspect." "What about the trespassing?" I asked. "You can absolutely press trespassing charges, but that will be against the individual tour guides and tourists, not the HOA. The better approach is probably to go after the HOA for the fraudulent representation and to get an injunction preventing anyone from using your trails." We agreed on a plan. Mitchell would draft cease and desist letters, and we would file for a temporary restraining order and preliminary injunction. I would also file a formal complaint with the Alaska State Troopers about the fraud. The cease and desist letters went out on Monday via certified mail. By Wednesday, my phone rang. It was Patricia. "Yates, I just received a very hostile letter from your attorney. I think you're overreacting to what is essentially a miscommunication. You told a tour company they could use my property for profit," I said. "You created maps of my trails and represented them as community property. That's not a miscommunication, that's fraud." "That's a very strong word," Patricia said, her voice tight. "The HOA was simply trying to create amenities for the community. We thought we were being good neighbors by maintaining and promoting trails in the area. You weren't maintaining anything. Those are my trails that I built and maintain. You have no claim to them whatsoever." Actually, Yates, if you look at the county records, you'll find that there are several historical easements that cross your property. Some of those trails may actually be public right-of-ways. I felt a chill. "What easements?" "I'm not going to do your research for you," Patricia said. "But you might want to check before you start making legal threats. You might find that the situation is more complicated than you think. Perhaps we should all sit down and discuss this reasonably." After she hung up, I immediately called Mitchell back. "She's claiming there are easements on my property." "Is that possible?" "Anything is possible," Mitchell said. "But you said you had the property surveyed when you bought it. Were there any easements noted?" "No," I said. "The title was clean." I specifically asked about easements because I wanted to make sure I had full control of the land. "Then she's probably bluffing," Mitchell said. "But we should verify. I'll have a title search done just to be safe. In the meantime, don't engage with her directly anymore. All communication should go through me." The title search took 3 days and cost me $400. The result was exactly what I expected. There were no easements on my property. There were no historical rights-of-way. Patricia had been lying. Mitchell sent another letter to the HOA, this time including the title search results and explicitly accusing them of making false statements about the property. He also filed our motion for a temporary restraining order. The hearing was scheduled for the following Monday. I took the day off work and drove to the courthouse in Fairbanks. Mitchell met me there and we went over our presentation. We had the property records, the photographs of trespassers, the emails from Patricia, and statements from Dale Pritchard at the tour company. Patricia showed up with her own lawyer, a slick-looking guy named Richard Foster who wore an expensive suit and carried a leather briefcase. With them were 2 other members of the HOA board, a man named Donald Crawford and a woman named Susan Martinez. The judge was a no-nonsense woman in her 60s named Judge Margaret Sutherland. She listened to Mitchell's presentation first. He laid out the facts clearly. I owned the property. I had built and maintained the trails. The HOA had no authority over my property. Despite this, they had represented to a commercial tour company that they controlled the trails and could grant access. This had resulted in repeated trespassing, and I was seeking an injunction to prevent further trespassing and to prevent the HOA from continuing to make false claims about my property. Judge Sutherland looked over the documents, including the emails. "Mr. Foster, what is your response to this?" Richard Foster stood smoothly. "Your Honor, while my clients acknowledge that there may have been some confusion about the precise ownership status of the trails in question, they acted in good faith to promote recreational opportunities in the area. The Northern Lights Estates HOA has a legitimate interest in promoting community amenities, and they believed they were acting within their rights." "Did they believe they owned the trails?" Judge Sutherland asked. "They believed the trails were community resources," Foster said carefully. That's not what I asked, the judge said. Did they believe they owned the property on which the trails are located? Foster hesitated. They believed they had the authority to manage access to the trails. Based on what? The judge asked. I'm looking at the emails here and Miss Kendrick explicitly told the tour company that the HOA controlled the trails and could grant commercial access. She accepted payment for trail maintenance. Mr. Kellerman's property records are clear. There are no easements, no shared rights, nothing that would give the HOA any authority. So where did Miss Kendrick get the idea that she could grant commercial access to someone else's private property? Patricia's lawyer didn't have a good answer for that. He tried to argue about community interests and the importance of recreational access and good neighbor policies, but Judge Sutherland cut him off. Mr. Foster, your clients don't get to unilaterally decide that someone else's private property should be used for the common good. This is a very simple property rights case. Mr. Kellerman owns the land. He has the right to exclude others. The HOA has been facilitating trespassing and appears to have profited from it. I'm granting the temporary restraining order. The HOA, its board members, and anyone acting under their direction are prohibited from entering Mr. Kellerman's property, from claiming any authority over his property, and from directing others to enter his property. Violation of this order can result in contempt charges. We'll have a full hearing on the preliminary injunction in 30 days. She banged her gavel and we were done. Patricia looked furious as she left the courtroom, whispering urgently to her lawyer. I thought that would be the end of it, but I should have known better. 2 weeks later, I got a call from the Alaska State Troopers. A sergeant named Mike Torres asked if I could come to the station to discuss my complaint about the HOA. I drove in that afternoon. Sergeant Torres was a big guy with a shaved head and a firm handshake. He had my complaint file on his desk along with several other folders. Mr. Kellerman, I've been looking into your fraud complaint regarding the HOA and their misrepresentation of your property. I've got some questions, but first, I want you to know that we're taking this seriously. We've interviewed Dale Pritchard at the tour company, and his story matches yours. We've also looked at the emails and the financial records. Financial records? I asked. The HOA collected payments from the tour company, Torres said. According to Mr. Pritchard, he paid the HOA $1,500 a month for what he thought was trail access and maintenance. That money went into an HOA account. We've subpoenaed their financial records, and it turns out the HOA collected over $10,000 from the tour company over the past 8 months. I felt my stomach drop. They made $10,000 from my property. Looks that way, Torres said. That moves this beyond simple trespassing. This is fraud and theft. Miss Kendrick and the HOA board were profiting from property they didn't own by lying about their authority to grant access. That's a crime. What happens now? I asked. We're going to bring charges, Torres said. I'll be honest with you, these cases can be tricky. Good lawyers can argue that it was a misunderstanding or that the board members believed they were acting within their authority. But the emails are pretty damning, especially the ones where Miss Kendrick is negotiating prices and talking about trail maintenance funds. It's going to be hard for her to claim she thought she was just being a good neighbor. Over the next several weeks, things escalated quickly. The district attorney's office filed criminal charges against Patricia Kendrick and 2 other HOA board members, Donald Crawford and Susan Martinez. They were charged with fraud, theft, and criminal trespassing. The charges were serious. If convicted, they could face up to 5 years in prison and significant fines. The story made the local news. A reporter from the Fairbanks Daily News Miner contacted me for an interview. I was hesitant at first, but Mitchell thought it might be good to get my side of the story out there. The article ran with the headline HOA accused of profiting from private property without owner's permission. The reaction in the community was mixed. Some people thought the HOA had overstepped badly and deserved what they got. Others thought I was being unreasonable for not sharing my trails, and that the criminal charges were too harsh. There were heated discussions on local social media groups and community forums. The residents of Northern Lights Estates were particularly divided. Some were embarrassed by their HOA's behavior and apologetic. Others seemed to think I was the problem. I got a few nasty emails and even a couple of phone calls from people telling me I was selfish and that I should share my trails with the community. One call stood out. It was from a woman named Deborah Wilson who lived in Northern Lights Estates. She was polite but firm. "Mr. Kellerman, I understand you're upset about how this was handled, but did you consider that by refusing to share your trails, you're impacting the entire community? We moved here because we were told there would be recreational opportunities. The trails were part of what we were promised." "Who promised you that?" I asked. "The developers and the HOA," she said. "It was in the marketing materials." "Did the marketing materials specifically mention my trails?" I asked. There was a pause. "They mentioned the Northern Lights Trail Network, which is on my private property," I said. "The developers and the HOA had no right to promise you access to my land. If you feel misled, you should take that up with them, not me." "But you could just let people use the trails," Deborah said. "It wouldn't cost you anything." "It would cost me my privacy, my control over my own property, and apparently, based on what the HOA did, it would expose me to liability if someone got hurt on my trails," I said. "Beyond that, it's my property. I bought it. I paid for it. I maintain it. I get to decide who uses it. That's what property rights mean." "I think you're being selfish," Deborah said. "And I think you're asking me to give up my rights so you can have amenities that you were falsely promised by other people," I said. "I'm sorry you were misled, but that's not my fault and it's not my responsibility to fix." She hung up on me. I felt bad for the residents who had been genuinely misled, but I wasn't going to let that guilt trip me into giving up control of my own land. The preliminary injunction hearing came and went. The injunction was made permanent. The HOA was barred from making any claims about my property or directing anyone to use my trails. Dale Pritchard's tour company had to completely redesign their tours and refund several bookings. He wasn't happy, but he understood that he had been lied to. The criminal case took longer. Patricia, Donald, and Susan all hired lawyers and pled not guilty. The case was scheduled for trial in 6 months. In the meantime, I had to deal with the aftermath. Despite the restraining order, I still occasionally found trespassers on my trails. Some were just local snowmachiners who didn't know about the dispute. Others were people who apparently thought the legal orders didn't apply to them. I called the troopers several times, and a few people got cited for trespassing. It was exhausting. I also had to deal with the civil case. Mitchell filed a lawsuit against the HOA seeking damages for the unauthorized use of my property, for the profits they made from my trails, and for the costs I had incurred in dealing with the situation. The HOA's insurance company tried to deny coverage, arguing that the board members' actions were intentional and fraudulent, which wasn't covered under their policy. This created more legal chaos. Spring came, and the snow melted. I spent my time maintaining my property and preparing for the summer. I love Alaska summers, the endless daylight, the wildlife, the peace. But this summer was different. I was constantly stressed about the ongoing legal battles. In July, I got a call from the district attorney's office. The DA, A woman named Jennifer Morrison wanted to meet with me about the case. I drove to Fairbanks and met her in her office. Jennifer was in her 40s, professional and direct. She had the case files spread out on her desk. "Mr. Kellerman, I wanted to give you an update on where we are with the charges against Miss Kendrick and the others," she said. "Their attorneys have approached us about a plea deal." "What kind of deal?" I asked. "They want to plead guilty to lesser charges in exchange for avoiding prison time," Jennifer said. "We're considering it because trials are expensive and unpredictable, but I wanted to get your input first." "You're the victim here, and your opinion matters." "What would the lesser charges be?" I asked. "Probably misdemeanor fraud and restitution," Jennifer said. "They would have to pay back all the money they collected from the tour company, plus your legal fees and damages. They would also have to step down from the HOA board and would be on probation for a year." I thought about it. Part of me wanted to see them go to trial and face the full consequences of their actions. They had lied, profited from my property, and caused me months of stress and expense. But another part of me just wanted it to be over. Trials are uncertain, and even if we won, appeals could drag things out for years. "Would they admit what they did?" I asked. "Yes," Jennifer said. "Part of the plea would be a formal admission of the facts. They would have to acknowledge that they fraudulently represented having authority over your property and that they profited from it. And I would get my money back, all of it," Jennifer said. "The tour company payments, your legal fees, your time and expenses. We would ask for a judgment of around $75,000 total, split between the 3 defendants. That was more money than I expected." "Would they be able to pay that?" "We've looked at their finances," Jennifer said. "It would be hard for them, but yes, they could pay it over time. We would structure it as a payment plan if necessary." I agreed to the plea deal. The trial was scheduled for August, but before it could begin, all 3 defendants accepted the plea agreement. We had a hearing where they formally entered their guilty pleas. I attended the hearing. Patricia looked much different than the confident woman who had shown up at my property 2 years earlier. She looked tired and defeated. When she addressed the judge, her voice was quiet. "Your Honor, I want to apologize to Mr. Kellerman," she said. "I made very poor decisions, and I let my desire to create amenities for our community cloud my judgment. I should never have represented that we had authority over his property. I should never have collected money from the tour company. I take full responsibility for my actions." Donald Crawford and Susan Martinez gave similar statements. The judge accepted their pleas and sentenced them each to 1 year of probation, 200 hours of community service, and ordered them to pay restitution jointly and severally in the amount of $73,000. They were also required to resign from the HOA board immediately. After the hearing, Patricia approached me in the hallway. Her lawyer tried to stop her, but she waved him off. "Mr. Kellerman, I really am sorry," she said. "I know that probably doesn't mean much to you, but I want you to know that I never intended to hurt you. I genuinely thought I was doing something good for the community." "By lying and stealing?" I asked. She flinched. "When you put it like that, it sounds terrible." But at the time, I told myself I was just being creative with problem solving. I thought if I could just get people using the trails, you would see how much the community appreciated them, and you would agree to keep them open. "That was never going to happen," I said. "You should have respected my answer the first time I said no." "I know that now," Patricia said. "I've lost a lot over this. My reputation, my position in the community, my savings. My marriage is probably not going to survive it either. I'm not asking for your sympathy, I just want you to know that I have learned from this." I didn't know what to say to that. I wasn't glad that her life had fallen apart, but I also didn't feel particularly bad for her. She had made her choices. "I hope you have," I finally said. "For what it's worth, I hope you figure things out." She nodded and walked away. I never saw her again. The civil case settled a few months later. The HOA's insurance company ended up covering part of the damages, despite their initial refusal. The settlement included payment of all my legal fees, compensation for my time and stress, and an additional payment for the unauthorized commercial use of my property. The total came to just under $100,000. Combined with the criminal restitution, I ended up recovering all my costs and then some. But the money wasn't really the point. The point was that I had defended my property rights against people who thought they could just take what they wanted because they decided it was for the greater good. The following winter, I was back on my trails without any interference. I had installed a better gate system at the entry points and had clearly marked the boundaries. I still got the occasional accidental trespasser, but for the most part, people respected the signs. Dale Pritchard, the tour company owner, called me in December. "Mr. Kellerman, I know we had a rough situation last year, but I wanted to reach out about something. I've been running tours on public land and some trails on the other side of the valley, but they're not as good as yours. I'm not asking for access, but I wondered if you might be willing to sell me some kind of easement or limited use license. I would pay fair market value and we would have a real legal agreement." I thought about it. What would that look like? "Maybe access 2 days a week, limited group sizes, and you would have veto power over any tours," Dale said. "I would pay you monthly and we would have a real contract. You would be in control the whole time." We negotiated for a few weeks and eventually worked out an agreement. Dale paid me $2,000 a month for limited access to my trails on Tuesdays and Thursdays only, with no more than 8 people per tour, and I retained the right to cancel tours if I needed the trails for my own use. It was a good arrangement. I made money, Dale got to run his tours, and everyone knew exactly what the rules were. Some people in Northern Lights estates complained that I was letting a tour company use the trails but not residents. They said it proved I was just greedy. I didn't care what they thought. Dale and I had a business arrangement based on mutual respect and clear legal boundaries. The HOA had tried to steal from me. There was a difference. The new HOA board at Northern Lights Estates reached out in the spring with a more reasonable proposal. They offered to pay for a separate trail system on some adjacent public land if I would provide a map of my trail layout so they could design something similar. I agreed to that. It seemed like a fair compromise. They got their trails, I kept my privacy, and everyone stayed on their own property. 2 years after the whole mess started, I was sitting on my Snowmachine on a ridge overlooking Denali. It was a clear February morning, and the mountain was brilliant white against the blue sky. My trails were quiet except for the sound of my machine and the wind in the trees. No tourists, no trespassers, no HOA board members trying to take what wasn't theirs. I thought about everything that had happened and realized that despite the stress and expense and time, I was glad I had fought. Property rights matter. Privacy matters. The principle of being able to say no and have that decision respected matters. If I had backed down, if I had let the HOA bully me into giving up control of my land, it would have set a precedent. They would have done it to someone else. I fired up my machine and headed down the trail toward home. The snow was perfect, the path was clear, and the land was mine. That was exactly how it should be. When I got home, I found a letter in my mailbox. It was from Patricia Kendrick. Inside was a check for $6,000, the first payment on her restitution. There was also a note. "Mr. Kellerman, I am continuing to work on making things right. I have completed my community service and my probation is going well. I have moved out of Northern Lights Estates and I'm living in a smaller place in Fairbanks. I got a job working for a non-profit that helps people understand property rights and legal boundaries. I suppose there is some irony in that. I tell everyone I meet about my mistakes and what I learned. I hope that in some small way, my experience can help others avoid making the same errors. I know this doesn't undo what I did, but I am trying to move forward in a better way. I hope you are well. I put the check in my bank account and filed the letter away. I appreciated that she was trying to make amends, but her journey wasn't my concern anymore. My concern was my land, my trails, and my life. The next Saturday, my friend Jackson came up from Anchorage to go snowmachining with me. We spent the day running the trails, racing each other on the straightaways, and stopping at the ridge to eat sandwiches and look at the view. "Man, these trails are incredible," Jackson said. "I heard about all the drama you went through with the HOA. That must have been terrible." "It was," I said, "but it's over now." "Was it worth it?" he asked. "All the legal stuff and stress and everything." I looked out at the wilderness spread before us, at the trails that I had built with my own hands and my own money, at the land that I had fought to protect. "Yeah," I said, "it was worth it." We finished our sandwiches and headed back down the mountain. The sun was starting to set, painting the snow in shades of orange and pink. My trails cut through the forest like ribbons, familiar and safe and mine. That night, sitting in my cabin with a fire in the wood stove and a beer in my hand, I thought about what it means to own something. Not just legally, but really own it. It means having the right to use it as you see fit. It means having the right to exclude others. It means having the right to say no without having to justify yourself. And it means having the responsibility to defend those rights when people try to take them away. The HOA had tried to convince me that being a good neighbor meant letting them use my property. They had tried to make me feel selfish for wanting to keep what was mine. They had tried to take by deception what they couldn't get by honest means. And when I stood up to them, they had tried to intimidate me with claims about easements and public access and community interests. But at the end of the day, the law was clear. The property was mine. The rights were mine. And nobody, not even an HOA that claimed to represent the community, could take that away without my permission. I got a few more calls over the following months from people in Northern Lights estates. Some were apologetic about how things had gone. Some were curious about how my trails were maintained. A few even asked if there was any way they could get personal access, just for themselves, maybe in exchange for helping with maintenance. I turned them all down politely. It wasn't that I was holding a grudge against the whole community for what the HOA board had done. It was just that I had learned my lesson about mixing my private property with other people's desires for access. Every time I said yes to someone, it would create an expectation. It would create questions about why I said yes to this person but not that person. It would open the door to future conflicts. My trails stayed private, and I was happy with that decision. The criminal restitution payments came in monthly. Patricia never missed a payment. Donald and Susan were less reliable, but eventually they paid what they owed. The whole experience had cost them financially and personally, and I took no pleasure in that, but I also didn't feel guilty about it. They had made choices, and choices have consequences. In the fall, I got contacted by a writer from Alaska magazine who wanted to do a story about property rights disputes in rural Alaska. She interviewed me about my experience with the HOA. The article came out in December and was fairly balanced. It talked about the growing tensions between development and privacy, between community amenities and individual rights, and between HOAs that overstepped their authority and property owners who pushed back. The article quoted me saying, "I'm not against communities or neighbors helping each other. I'm against people thinking they can take what isn't theirs just because they've decided it would be nice to have. There's a legal process for acquiring property rights. The HOA didn't follow that process. They just took what they wanted and hoped I wouldn't notice or wouldn't care enough to stop them. The article generated some discussion in Alaska community forums. Most people seemed to agree that the HOA had been wrong, though there were still some who thought I should have been more accommodating. One person commented online, "This guy sounds like a jerk. It's just some trails. Let people enjoy them." Someone else responded, "It's not just some trails. It's his property that he bought and paid for and maintains. Would you let strangers use your backyard just because they thought it was nice?" I didn't engage with the online debates. I had said what I needed to say, and people were going to have their own opinions regardless. By the time the second winter rolled around, the whole situation had mostly faded from public attention. Dale's tour company was doing well with our arrangement, and the Northern Lights Estates HOA had built their own small trail system on public land nearby. It wasn't as extensive as mine, but it gave their residents something to use. I ran into one of the new HOA board members, a guy named Frank Peterson, at a gas station in Fairbanks. He recognized me and came over to introduce himself. "Mr. Kellerman, I'm Frank Peterson. I'm on the HOA board at Northern Lights now. I just wanted to let you know that we've implemented new policies to make sure nothing like what happened with Patricia ever happens again. We have better oversight, better legal review of our actions, and we've made it very clear to everyone that the HOA has authority only within our subdivision boundaries." "That sounds like a good idea," I said. "I also wanted to apologize on behalf of the community," Frank said. "What Patricia did was wrong, and a lot of us were horrified when we found out. We hope you don't judge all of us by her actions." "I don't," I said. "I understand that every community has people who make bad decisions. I'm glad you've made changes." We talked for a few more minutes and then parted ways. It was a positive interaction, and it helped me feel like maybe something good had come out of the whole mess. Maybe other HOAs in Alaska would be more careful about overstepping their boundaries. Maybe other property owners would be more willing to stand up for their rights. 3 years after it all started, I was completely free of the legal entanglements. All restitution had been paid, all probations had been completed, and all civil cases had been settled. My trails were still private, still well-maintained, and still mine. I expanded my trail system that year, adding another 10 miles of trails that looped through a particularly beautiful section of forest. I did it because I wanted to, because I enjoyed the work, and because I could. That was the whole point of owning property in Alaska, the freedom to do what you wanted with your own land. Dale asked if he could include the new trails in his tours. We renegotiated our agreement and I raised the monthly fee. He agreed without complaint. It was fair compensation for the use of my property, and we both benefited from the arrangement. On a Saturday in March, I was running my trails alone when I stopped at a new overlook I had created. The view was spectacular. I could see for miles across the wilderness, white snow stretching to the horizon, mountains rising in the distance, and not a single building or person in sight. This was why I had moved to Alaska. This was what I had fought to protect. I pulled out my phone and took a picture. Not for social media or to show anyone else, just for me. A reminder of what mattered and what I had been willing to fight for. As I rode back toward home, I thought about how the whole experience had changed me. I was more cautious now, more aware of how people could twist words and situations to suit their needs. I was more careful about what I agreed to and more willing to say no without feeling guilty. I had learned that being nice and being a pushover were two different things, and that defending your rights wasn't the same as being difficult. The HOA had taught me that some people would always see your boundaries as obstacles to be overcome rather than rights to be respected. They had taught me that good intentions didn't excuse bad actions. And they had taught me that sometimes you have to fight, even when it's expensive and stressful and time-consuming, because if you don't stand up for your rights, no one else will. I pulled into my driveway as the sun was setting. My cabin looked warm and inviting, smoke rising from the chimney. My land stretched around me, 47 acres of Alaska wilderness that was mine in every sense that mattered. I had the deed, I had the boundaries, and I had the legal precedent from multiple courts confirming my rights. The HOA had tried to take it from me, and they had failed. That failure had cost them money, reputation, and in Patricia's case, much more. But it had also taught them, and everyone watching, that property rights in Alaska still meant something. That you couldn't just help yourself to someone else's land because you thought it would be nice to have. That legal boundaries existed for a reason. I parked my snow machine and walked into my cabin. The fire was still burning from the morning, and the cabin was warm. I made dinner and sat by the window, looking out at my land as night fell. The stars came out, brilliant and clear in the Arctic sky. The northern lights began to dance, green and blue curtains of light shimmering across the darkness. It was beautiful. It was mine. And that was exactly how it was going to stay.